This is WPSL Port St. Lucie.
The opinions expressed on this program are those of the program host and guests and are not those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Call in with your questions and comments at 340-1590, 340-1590. Now with Ask a Lawyer, here's your host, Attorney Stuart M. Address. Good morning.
Good morning. Good morning, everyone. I am Stuart Address, and this is the first edition of Ask a Lawyer. I hope you're all enjoying your morning and what we're going to be doing this week and over the course of however long we last until we're canceled. Is I'm going to take your questions about whatever legal topics interest you, whatever legal situations you may have, whatever comments about the legal profession you may want to make or discuss. And hopefully there'll be some interesting information I can impart. And who knows, maybe you'll all teach me something here and there. Let me tell you a little bit about myself. I have a law firm in Stuart. We generally do all sorts of civil litigation, which means we don't do criminal law, and it means that's about mostly all we don't do. I do a lot of employment law, a lot of discrimination, civil rights, things of that nature. But whenever you have a civil litigation firm, a lot of things walk in the door, and I've done a lot of things over the past 30 plus years. Started out my career a long time ago in very large law firms in New Jersey, where I'm from, 200 size attorney firms, and decided I could not stand the bureaucracy, could not stand the red tape. So I went from 200 to about 100. Still had a problem.
Still a little too big,
Didn't quite fit for me. So I went from that to about 15. I found that too large. And from there I went here to Stuart. I went to a firm when I came over to Stuart in 1996. And it was a two-attorney firm.
You can tell us who they were.
It was Rubin & Rubin.
Okay.
And I enjoyed that. I was there for more than a decade. We had a great run. And then I decided I want to be the boss. Mm-hmm. And, it's not those typical reasons to be the boss. In a law firm, I wanted to be the boss so that I could deal with my clients directly. I could make the decisions that needed to be made without having to get approval. And I could focus on my clients personally. So that is a little bit of who I am. And I don't believe in taking myself too seriously. Lawyers seem to have a bad rap these days, and I certainly don't want to make it worse.
But lawyers and car dealers, is that? Yeah.
Well, let me tell you something about that. That's a funny thing you say that.
I do joke.
It's fine. When I was in high school, way back in the late 70s, and there was a study that came out. It's like the top 100 professions and how they were viewed by the general public. Number one on the list was President of the United States. Number two were lawyers.
Okay.
I saw a study, maybe 5 years ago. Last was President of the United States, and next to last were lawyers. So we've had a 180 flip.
How the tables have turned.
It has turned. And, there's a reason for that, in my opinion. The biggest complaint about lawyers, generally, and to the Florida bar, is lack of communication. Lawyers who don't answer phone calls, don't respond to emails, don't tell their clients what's going on, and a year goes by. That is the number one grievance. And when you don't communicate with your client, they're not going to be happy with you, even if you end up doing well. They're going to have a bad taste in their mouth. I have had clients, and in the end, we have not done so well. But for the most part, they were happy with me, and they felt that at least they had been heard, in a courtroom if it went to a trial. Not all of them were thrilled if it didn't work out well, but a good many were happy to just have been heard and to have known that, I was taking them seriously. So a lot of people come into my office complaining about other lawyers. And, sometimes I tell them to go try to work it out, and sometimes I take over a case. I think most lawyers have had that experience. So, I'm going to try not to take myself too seriously. If you have a call and you have a grievance or you want to discuss some problems in the legal profession or a justice system, go ahead and do it. You're not going to upset me. As a matter of fact, there's a sort of a joke in a book that I like. It's called Lawyers and Other Reptiles. And I'm from New Jersey.
You see why you slipped down that
right,
list.
Exactly.
Okay.
I'm from New Jersey, so I'm allowed to say this. The joke is Washington, D.C. has the most lawyers, and New Jersey has the most toxic waste dumps. Why? Because New Jersey had first choice. Mm-hmm. That's what we think about lawyers. So, given that we have that little bit of a problem, my goal is hopefully to educate you folks and give you some information that you might want, have a little bit of fun, tell some jokes, tell some war stories, maybe give you a little bit of a fresh look on the legal field, and hopefully if you need a lawyer, you encounter one who communicates with you, who takes you seriously, and you walk away with a good feeling about a legal system, even if the last thing you really want to do in life is have to need a lawyer.
And of course, you can call us here today and get like a mini free consultation.
That's right.
340-1590.
I will do the best I can. All right, so let's start. Little bit of a story. I do this in voir dire in trials. A lot of attorneys do it now in voir dire when you're questioning the jury panel, trying to pick a jury. And what you're doing when you do voir dire is you're trying to figure out biases and prejudices and just, different feelings about different topics so you can find the kind of juror you like. But one of the big issues is, do jurors believe that we have a runaway system and that too much money is awarded and it's not fair? So a lot of us now use the McDonald's hot coffee case. You familiar with that case?
Vaguely, but
Okay.
we've all heard the hot coffee and I sued kind of thing.
That's right. Hot coffee, I sued,
Yep.
and I got millions of dollars.
Yes. So every time I get a really hot cup of coffee that I can't hold, it needs that little paper sleeve, but it doesn't have one, I go, I need to sue somebody.
Well, I'll tell you something. A few years ago, I went through a McDonald's drive-thru, and the top was not put on very carefully, and as I drove away, it spilled on me.
Oh,
I did write them a letter, but I didn't get any money.
okay.
And I didn't really push
Not
it.
even a free coffee.
No, not even a free coffee. So let me tell you, folks, a little bit about what we do in voir dire. I'm going to give you some facts about the case and see if maybe in the end you sitting there at home or at work or in the car might say, oh, gee, I didn't know that, and maybe I have a different perception. If so, that's sort of what we're trying to do in voir dire. As a lot of you know, a woman got some hot coffee and it spilled and she got badly burned. The woman was 79 years old. She had gone through a drive-through window with her grandson. She had purchased a cup of hot coffee. As her grandson was driving away from the drive-through window, she put it between her legs so that she could open the top and put in sugar and creamer. Being 79, she couldn't do it with one hand. It was just, she didn't have the dexterity. So as her grandson really started to accelerate, well, the coffee went everywhere. And since it was in her lap, it ended up on her legs, in her crotch, and she got third-degree burns over 6% of her body. Now, third-degree burns are the worst burns that you can get. They are burns which will not heal without skin grafting. They're burns that go through all layers of the skin. So at that time, McDonald's was selling their coffee. Well, actually, they were brewing their coffee at a temperature of 195 to 205 degrees. And they were selling the coffee at a temperature of 180 to 185 degrees. It turns out, as the evidence came in at the McDonald's trial, which a lot of people don't hear about because you don't always hear on the news.
No, well, the trial happens, it's drawn out after a while,
That's
and
right.
we're just not paying attention by
Well,
then.
it's not just that. It's that the jury often hears things that don't get reported.
Okay.
And so a lot of people, they hear a verdict, and they say, well, that's wrong. And it may be wrong based upon what you or I even have heard. But if you're sitting on the jury and you get all the evidence, it may not be so wrong. So let's hear a little bit about what the jury heard, okay, and why this woman got supposedly millions of dollars and it was horrible and unfair and, you know. Anyway, so she, it turns out that even McDonald's engineers testified that coffee is unsafe to drink at 180 to 190 degrees. It will cause burns to the throat if swallowed within the first few minutes, and it will cause severe burns even at 130 degrees. So it turns out that between 1982 and 1992, McDonald's had 700 reported cases of burn complaints arising from their coffee. They paid out settlements. They did not change the temperature at which they brewed their coffee or at which they held the coffee and then sold the coffee to the customer. Men, women, children of those 700 were burned, and some of them, again, in their genital areas. I suspect that more than 700 people were really burned. It's only those 700 complained. So McDonald's had known about the hot coffee problem for 10 years. They had not changed the temperature at all. During the trial, they admitted, McDonald's employees and, you know, higher-ups, admitted to these prior complaints. They admitted that they had taken no action to reduce the temperatures, and they testified that they had no plans on taking actions to reduce the temperatures. It said that the 700 number was statistically trivial. That is the type of thing.
Oh, and in comparison to the number of cups of coffee that they sell. Okay.
And statistically trivial, you know, in my view, is the kind of thing that angers a jury.
Do you think that McDonald's was looking at it like, okay, customer error too?
Well, they did make that argument.
Coffee,
sure.
It's hot.
Sure, absolutely. They made the argument that, you know, look, everybody knows that hot coffee is hot. And I think that's a fair argument. And it turns out that this grandmother of 79 was found 20% responsible for her own burns. McDonald's was found 80% responsible. It's called comparative negligence. And so ultimately the jury verdict, which we'll get to, was reduced by the 20%. Jury doesn't know that. It happens after the trial. So McDonald's admitted that people over 65, like this woman, are also at increased risk for coffee spills, and they're probably unaware that they can get third-degree burns from a spill. They testified that at the temperature they sold it, it was not fit for human consumption. That's their language from the trial, not mine. And experts testified that most stores selling coffee sold it at between 150 and 165 degrees, so about 30, 35 degrees cooler than what McDonald's was doing. Now, it turns out that the facts that came out at trial were at 180 degrees, third-degree burns occur within 2 to 10 seconds. Doesn't take very long. If you go down just a little bit to 170 degrees, it takes 20 to 30 seconds to get those kinds of burns. You know, maybe you have time to get some napkins or some cold water.
It probably also depends on her clothing, too.
Well, right. She was wearing jogging pants, and it adhered to her skin.
Sure.
Okay? If you go down to 155 degrees, it takes 60 seconds to get those types of burns. So, you know, with a spill, it's probably not going to happen. You're going to be able to fix it within the 60 seconds. So, as I said, the jury found McDonald's 80% at fault and the plaintiff, the woman, at 20% at fault. They awarded what are called compensatory damages, you know, lost income, pain and suffering, was $200,000. And then they awarded $2.7 million in punitive damages. And that's sort of what folks hear. That's really started the move towards what they call tort reform. You know, that's a buzzword. And tort reform means let's cut jury verdicts. So that's not the number she got. First of all, the court immediately reduced it by 20%. So in terms of compensatory damages, it went down to $160,000. And the court took the $2.7 million and cut it immediately down to $480,000. Because,
well, that's a big cut.
Well, that was a very big cut. And I forget what state this occurred in, but a lot of states have statutes that limit punitive damages. For a while, and I'm not sure if it's still the case, I don't think it is, but for a while Florida had a statute where punitive damages would be no more than 3 times the compensatory damages. So whatever state this was, that $2.7 million was already reduced to $480,000. And then we took 20% off of that. Mm-hmm. So you got down to $385,000 for punitive damages. This woman did not get $1 million. In fact, she got even less than the $160,000 and the $385,000, which, if my math serves me quickly, is about $560,000. She got a lot less than that because McDonald's said, well, we're going to appeal. And so they had a confidential settlement to avoid an appeal. We don't know the number she actually got, but I suspect it's substantially south of $500,000.
Sure.
Now, when we give all this information, to a voir dire jury panel, we're asking questions along the way. Before we even start, we're saying, well, okay, how many of you, raise your hands, how many of you think that the punitive damages awarded in the McDonald's hot coffee case was absolutely outrageous and runaway? And almost every hand typically goes up. Mm-hmm. Okay? Then we start telling some of this story, and we ask again, how many of you still believe? And we'll go to some of the people who do and just ask questions. But you notice the number of hands tends to come down. Mm-hmm. And then when we're done, with the story at least, we say, how many of you now believe that the verdict was unfair? Now, we'll still get hands. There's no doubt. People have different opinions. But I dare say that in most prospective jury panels, less than half of the people, maybe even a third, raise their hands, as opposed to almost unanimous when we started. If you have a case that involves punitive damages, that's a very effective job of educating the jury. So the moral of the story is essentially that when we don't realize everything the jury hears, all the facts they hear, all the expert testimony, all the admissions, we may have a wrong sense of what really happened when we get, the 15-second soundbite as to what happened in a case. I don't know out there if any of you, still feel it's a runaway jury. If you feel that maybe I've changed your mind a little bit, why don't you give us a call? Tell us what you think. Tell us if you were on my jury panel and I was asking you this question, would you still be raising your hand saying this is unfair? And maybe we can talk a little bit about why. Or give us a call and tell me if maybe I didn't know that, and this particular fact or that particular fact, that changed my mind a little bit. Because whenever you hear of any case, and I'm not going to give opinions on all these cases, but when you hear O.J. Simpson case, and of course, most people, he was guilty in terms of the criminal trial. There are things that I know, maybe we could talk about that on another show, that the jury heard.
I followed that one closely.
Yes, I did too, very
Yeah,
closely on TV. The average person didn't hear. And there's a reason why he was found not guilty in the criminal trial and liable in the civil case. We can talk about that too. Mm-hmm. It's difference in the burden of proof.
And that still goes on and on and on.
Yes, that goes on. That's going on right now with Robert Goldman seeking money that he's getting from his autographs to pay down the judgment which he got against O.J. Simpson in the civil trial. And while that motion hasn't been heard, I think I can give you a fairly educated guess that Mr. Simpson is not going to be able to keep either any or very much of those proceeds at all. Mm-hmm. He's either going to do these things, make some money because he wants to go out and press the flesh and get some adoration.
Well, he still wants to be O.J. Simpson, and he still wants people.
He's not going to make much money for the rest of his life, or if he does, it's mostly going to go down to pay that judgment. And there are other cases like that as well. So, having no calls yet.
Well, let's give the phone number real quick,
All right.
340-1590. Give us a call here in the studios. It's Ask a Lawyer, so give us a call.
And that's either you want to talk about the McDonald's case, you want to talk about another case,
Or your case.
or your particular case.
Maybe you don't know you have a case.
That's right. A lot of people call my office. Some say, well, I have a case and I have a great case. And, we talk to them. We do a screening. Turns out they don't have a case or they don't have a great case.
Mm-hmm.
But there are people who haven't called. They finally call us and they say, well, somebody told me to call. And it turns out they didn't call before because they didn't think they had a case. Now a friend says, call a lawyer. Turns out they really had a great case.
I like this. It's Ask a Lawyer with a real lawyer, not a paid spokesperson.
Yeah, nobody's been giving me big bucks. All right, so let's go to one of the topics. What I'm going to be doing in each of these weekly shows on Friday at 10 is pick out one or two areas of law that I tend to practice and talk a little bit about it, what the elements of a cause of action are, things that I think that occur in a good number of situations that people that are listening may be relevant to. And the first one, well, we may have a question.
You'll need to put on your headphones.
May have a question before we move into this secret area that I haven't told you about yet.
We do, and then we are going to break for Florida State News at the
Okay.
bottom of the hour, so our call may take us right to that.
Very good.
So this is Bulldog. Morning, Bulldog.
Good morning. How are you?
I'm great.
I do have a question for our new lawyer, and welcome. When do you decide whether you want a jury trial or bench trial? You were talking about voir dire and everything, and I said, is it if you're going to be tried where you don't think the jury pool is going to be what you want it to be, or that because you know in advance who the judge in the case is going to be, so does that sway your decision on that?
That's a very good question, Bulldog. Let's take that in several different parts. You have to make the decision if you're the plaintiff when you file the complaint. If your complaint does not contain a jury demand, then unless the other side responds with a jury demand, there is no jury and there's no way to get a jury. If you don't ask for a jury in the complaint and the other side doesn't ask for a jury when they answer, then there's also no jury even if one of you decides you want a jury. So it's
All
a
right,
decision.
May I ask
Sure.
you to clarify that? Sorry to interrupt.
No, it's okay.
So if you're saying if the plaintiff wants a jury and you're the defendant, you've got no choice.
Right. If the plaintiff asks for a jury, that's it. You're done. There's a jury.
Okay, so defense does not have a choice on whether to go to bench or jury.
No. If the plaintiff does not ask for a jury, then the defendant has a choice. When they file their response, they can ask for a jury, in which case the plaintiff has no choice. It is a jury case.
Right. Okay.
Now, in terms of trying to make that decision up front with your lawyer as to, well, do I want to demand a jury, whether you're a plaintiff or a defendant? Yes, you do look at who is the judge. You look at the type of case you have. Is it the type of case that is going to be really confusing to the average juror and the type that you think a judge will understand better and give a fairer decision? Go ahead.
Yeah, and also the demographics of if it's not change of venue, then you've got to look at the demographics and what you're going to get in a jury pool.
That's also very true. Each county has different demographics. You sort of, most attorneys know what the jury pool is going to look like. How much is going to be retirees. How many people are going to be, own small businesses. How many people, are stay-at-home moms. Things like that. How many people are going to be lawyers or doctors. And you also tend to know, for the most part, racial makeup, demographic makeup.
Right.
And, look, let's be realistic. I do discrimination law, civil rights law. While that shouldn't really be a factor, it is. And,
it is.
And every jury, if they don't acknowledge that, they're not telling the truth.
Well, and age demographics as well, because certain people have different outlooks on things that, younger X generation, looks at things differently. It's like if you were doing a pot case, Generation X is going to say, oh, come on, misdemeanor. And they're going to say, lock them up,
Well, that's right.
Crowd. I mean, yeah, and it's just a wild exaggeration, but it's not far from truth.
No, you have a very good point there. And so I would say, really, when I am making that decision with my client and making the recommendation to my client so that they make the ultimate, let's do this way or do it that way, I'm really looking, for the most part at what the case is and how complicated it's going to be. And also, if I'm a plaintiff asking for money, I am more likely to get more money from a jury than I am from a judge. A motion which is not supposed to play a role in your decision. Baloney. Lawyers in closing arguments are trying to play on jurors' emotions. All right? You're more likely to get more money from a jury than you are from, even the nicest stuffy judge.
All right, good. Then I'll take you into the O.J. Simpson case.
All right.
So he's innocent on that one. Then he goes to civil. Does he have the same bench versus jury option there?
Yes. In criminal, in criminal, he has the option, if he wants a bench trial, but, depending upon the case, very few elect that. And, of course, in the criminal case, the decision had to be beyond a reasonable doubt. And there were a lot of things, without going into them now, that happened in that case that, led to a reasonable doubt. Everybody's familiar with, if the glove don't fit, you must acquit, which was just a great stunt by Johnny Cochran, and it worked very effectively. But when you went to the civil case, first of all, you now had a different burden of proof. Instead of beyond a reasonable doubt, it's a preponderance of the evidence. Well, what's that all mean? Beyond a reasonable doubt, without giving it a fixed percentage, because the law doesn't do that, I would say if you're sitting on the jury, you have to sort of be 95% convinced.
I was going to go 90, but you're probably right.
And to feel comfortable saying guilty, knowing that you're going to lock somebody up, depending upon the type of case.
Preponderance is a 51%.
It's 50% and a feather. It's just that slight of a difference where if you and I are at a cocktail party and we're telling a story and somebody else has to make a decision about who they believe, all it is my gut feeling, I believe that you're right, and that's a preponderance of the evidence.
Okay. Now I'll put you on the fire here. What made the difference between 51 and 90 or 95?
That is a question which could probably take up 2 shows, if not an entire season. I think they've done miniseries on that. Gut
call on it real fast. What do you think?
I think the evidence was probably pretty clear that he had been involved
in something.
Well, in the deaths. It couldn't just be something.
I'm sorry. Did you see the picture of him wearing those gloves?
Yeah.
Okay.
And where they were dropped and all those other things.
And where blood ended up and
yes.
all that good stuff.
I think it was fairly easy for a juror in the civil case to conclude, I think he did it.
Mm-hmm.
Whereas
I think, Cato hung him out to dry, too. So, yeah.
Well, and that lovely, I forget his name now, it'll come to me, the police officer in the criminal case.
Mark Furman.
Yeah, Mark Furman. Did not do the state of California any favors.
No,
that
not.
If I was on the jury, that alone might have made me wonder whether or not I was going to convict.
The evidence handling was a little on the botch side.
A whole nother evidence. Gee, man, there are people that specialize in chain of custody and evidence, and we have them here even locally. I mean, it's an important topic, particularly in a criminal case.
Okay.
Thank you
so much.
You're very
for the
welcome.
Conversation.
Very well. Feel free to call back again.
I will.
Take care.
You.
So 340-1590, the number here at the station. We do have another call.
All right, wonderful.
John's been holding. I hope you're still there. John, you're on the air.
Yes, hi, good morning.
Good morning, John.
I wanted to find out, I didn't catch the beginning of the show. What type of law do you specialize in?
Well, it's funny. As the Florida Bar says, we can't say what we specialize in unless we take certain tests and we're certified in that area. So I can tell you what areas of practice I do most.
Okay.
For the most part, I do a lot of employment-based litigation, on the employee side, things like discrimination, disability, family and medical leave, which we're going to go and talk to probably after the break. I also do civil rights, where people have complaints that either the police or some entity of the state has taken some action which violated, their civil rights. Beyond that, it's a wide variety of things. I mean, I do non-compete trade secret litigation, landlord and tenant, overtime. As a civil litigation attorney, you're for the most part a jack of all trades. There are certain areas that you choose not to do a lot of. I certainly have those areas. But I would say for the, probably half of my practice is employment-based litigation or civil rights.
All right, good. Pretty wide area then of things that you're involved with. I appreciate that, and looking forward to hearing you. I guess you're on every Friday
It's going to be
now?
every Friday at 10 a.m. Right after Swap Shop.
Looking forward to it. Good luck to you, and we'll be listening.
Thanks very much for calling.
Okay, thank you.
By the way, if we still have any Swap Shop folks listening, if that gave me a great lead-in, which is what I'm hoping, give us a call, because Cliff is still here, and he'd love to know that you stayed around to listen to me.
340-1590, the number here at the station. We did talk through the news, so we won't be taking that break.
Oh, my goodness.
Because
You mean I preempted the news?
That happens with or without us, so we just kept with the calls, which is fine. So we're looking forward to more calls, but if you'd like to take a break, let me know.
No, I'm fine. I'm just honored that I preempted the news. I mean, I'm not that important, but okay. Let's go into our next area. The area I really wanted to talk about today, and we may not finish it, maybe we will, is family and medical leave.
Okay.
I've had a good number of cases in that area, and frankly,
my mind is a little boggled why I would need an attorney for that.
All right, well, let's give you an example of why you might need an attorney. The Family and Medical Leave Act is a very odd statute in a way. It would never, in my view, be passed today, but I'm glad it was. Most statutes, the discrimination statutes, civil rights statutes, the burden is on you, the person who is complaining, to complain. In the Family and Medical Leave Act, the burden is on the employer to offer you the family and medical leave paperwork if they have the inkling that you may be entitled to FMLA leave. It's an amazing difference. If an employer fails to offer the paperwork, it's an interference violation. Now, it's a technical violation of the FMLA, doesn't carry with it big bucks. But if the employer thereafter does something really horrible and the jury hears, well, they never even offered the paperwork, it tends to increase, I think, the value of the case. And so a very nice woman whose case I handled turned into a 3-week federal jury trial in Fort Pierce at the old courthouse before they moved to the lovely new courthouse. She and her husband and her family, they've become friends with my family now after all these years. Sometimes you tend to bond with your clients. And when you go through a long period of time, especially as a solo attorney, you spend a lot of time with these folks. She called the office, and I was on 95, and my paralegal, gave me a call and said, we just got a call. And, I didn't even talk to her at that point. I said, she called and said, I walked into my job. I had to leave immediately because my daughter was threatening to jump off the bridge, the Fort Pierce Bridge with the baby. And I had to go deal with, Baker acting and the police and everything else. And they wouldn't let me leave. And finally I got out, and then I asked for a few days off to deal with these problems, and they said no. What should I do? Well, I said, the first thing you do is you send either a fax or an email, something that shows that you really sent it, saying FMLA. I'd like the FMLA packet. Well, sure enough, She said that, and they gave her the FMLA packet, and she got her 12 weeks of FMLA leave. Now, here's one of the problems. Under the FMLA, an employee is not supposed to have to ask. An employee is not supposed to have to use any magic words like FMLA. If your employer or your supervisor or somebody knows that, oh my goodness, you're going into the hospital for hip surgery, it's their duty, the employer's duty, to offer you the FMLA packet. You may not know the FMLA exists. You're not a lawyer.
Now, if you just get the time, do you need the packet?
Well, yes. A lot of employers will give it to you as leave. Well, you come back from leave and all of a sudden you find out you have a different job,
Okay.
a different salary, a different schedule. Are you protected? Well, probably not, because you weren't on FMLA leave. You were on leave. Now, there are attorneys, including myself, who will argue that the employer's failure to offer the FMLA packet converts whatever leave they gave you to FMLA leave.
Okay.
And there have been cases where that argument is successful.
Because the responsibility is on the employer.
Exactly.
Okay.
But you're much better protected if you fill out the FMLA paperwork, if your doctor fills out the certification, and if then there's that little part at the bottom that says approved. You know, there are two types of FMLA leave. There's when you need a certain period of time. You know, you may only need 2 weeks. Okay, you get 2 weeks of FMLA leave. If you need an extension, doctor certifies, the employer reviews it, and it's approved or denied, and if it's denied, there may be a problem. Maybe there's not if it's a legitimate denial. There's also intermittent FMLA leave. You may have a situation where, I don't know, you're caring for your child, and your child has some issue, some illness that requires periodic visits to the doctor, and you may not know when those issues are going to flare up. And you have to have that time. You are still entitled to up to 12 weeks of unpaid leave over the course of a 52-week year, a rolling 52-week year. In these types of intermittent situations, you may not be able to give advance notice or much advance notice of when you need time off. That's okay as long as you really couldn't and you're on intermittent leave. Because the general rule is you do have to give your employer reasonable notice of the time you need to take off. There are situations, a car accident, you may not be able to do it. That is okay.
Yeah.
But if you decide, I'm going to have elective surgery in 3 months, and then a week before the surgery you say, I need time off, you're probably going to lose if you sue them, because you just did not give proper notice. So, you know, that is, you often need a lawyer, first of all, unfortunately, to get the employer to do what they're supposed to do and give you the paperwork and give you the leave. And then you may not need a lawyer anymore, and that's wonderful. In this particular case I was talking about, she had her leave, she had her 12 weeks, was actually in the process of adopting the grandchild. The daughter was just not in any situation to take care of the child. And she went back to work, and she got a different job. Now, her salary didn't change, but it was a much lower prestige job. It was a completely different job. The job had different duties and responsibilities and authority. She didn't have the opportunity to get certain bonuses that she had in her old job. And so when we went to court, the big argument on what is called not the interference claim, but the retaliation claim, is that they failed to return her to a substantially equivalent position. Those are magic legal words that are in the statute, that are in the Code of Federal Regulations, which interpret the statute, and they mean something very particular. Essentially, it means that you have to be returned to either your old job or a substantially equivalent position where your duties and responsibilities and authority are roughly the same, where your compensation is within millimeters, roughly the same, where your opportunity for bonuses or other perks that the employer offers is roughly the same. It's understandable that somebody can be out 12 weeks and their exact job may not be available anymore, that the employer really did have to fill it. Even as a plaintiff's attorney, I have to admit that I see a lot of those cases, and it's very real, and employers have to do certain things to, have their business run. But you are entitled to return to a substantially equivalent position. And if the employer doesn't have one, then they haven't planned properly. Or maybe the person they put into your position should have been put in as a temp,
right?
Or somebody should have been shifted over temporarily. They should have known that you were coming back at a certain time and you have these rights, and they needed to prepare for it.
Now, if you sue, what are you suing to gain? What are you getting?
All right. In an FMLA case, you can get an injunction that returns you to your job. A lot of people at that point don't want to go back to that job.
I'm thinking it's not going to really make for good,
I would,
relations once you get back to work.
I would say that in the cases I handle, I don't think I've once asked for reinstatement, although that is one of the, an injunction to reinstate with your back pay and perks and benefits and all that is one of the options. Other than that, you're talking, what is the civil justice system all about? It's about one thing. It's about damages, okay? And let me say a quick word about damages. It's a poor substitute in many, many situations for compensating somebody who has gone through a wide variety of things. Money does not really solve a lot of problems. However, it is in lieu of being able to force apologies or flogging a person or hanging them up by their nails upside down. It's the best thing we got. And it's our system of justice. A lot of people complain about our system of civil justice, and there are a lot of complaints that are valid, a lot of things that should be changed. However, I and many other people before me have said this, and I believe it with all my heart. With as much that may be wrong with our civil system of justice, it really is the best in the world. You have a chance to be heard. You have a chance to be heard by an impartial judge and an impartial jury. It may not always go your way, but it's not going to be a show trial, whether it's criminal or civil. You're going to have your day in court if that's what you want. And so it's money. Okay, so what kind of money? In an FMLA case, the statute is fairly clear. You can recover past lost income, benefits, etc., from the date of what's called the adverse employment activity, the date of whatever it was that caused the litigation, to the date of the jury's judgment. Okay? So that's where we start. That's past through the date of the jury saying, you win. You can also ask the jury for what's called front pay. That's for a certain period of time into the future. That is harder for a jury to calculate. It's easy to calculate the past. It's hard to calculate the future. Let's say you're earning $50,000 a year. Well, is the jury going to give you front pay for 1 year, 2 years, 3 years, 6 months? That is an art, not a science. There is no law or regulation that tells a jury what it's supposed to do. Jury is supposed to look at each situation individually and decide what is it going to take to get you back into a similar position somewhere else at that level of seniority or whatever level it is to be making that kind of money.
Sure, because you may have worked for 15 years for that company, moving up that whole time,
right.
And that was your goal to continue to do that, and now that's changed.
Absolutely.
To start all over again.
Right. I represented a pilot who had worked for a particular airline for a long, long time and had gone way up the ladder, was making a very nice sum of money. And when he had his problem and finally was able to get another position, it was with one of these newer airlines. And he was making maybe a quarter.
Sure. How do you replace that?
Right.
Yeah.
So the way you replace that is you argue for front pay.
Okay.
And you argue usually based upon an expert. You have to hire an expert that comes in and looks at the Bureau of Labor Statistics and employment
Well, they kind of figure out what you were worth.
Exactly.
Okay.
And they testify and you testify as to your efforts to find a new job. And maybe you found one and we can say, this is what I'm earning and these are my prospects. But you try to get a jury to say, okay, look, it's going to take this person a year or 2 years to find a position that is roughly at the level of responsibility, authority, prestige, and money that they were making previously. And so you ask the jury then, give me front pay for this period of time. Now, as lawyers, negotiators, we ask for more front pay than we know is ever going to be awarded.
Sure.
Because we want the jury go in there and somebody's going to argue for less and they have room to give less and maybe give us what we really want. On the other hand, lawyers have to be careful. Don't go in and argue whole hog for give me 10 years of front pay, because you may just turn the jury off and
get nothing.
Right. So, it's an art and it's not a science, but that's the front pay. In addition, and here's a kicker, at least for the past damages from the date it happened to the date of trial, if you win, in most cases, an employer has to have been determined to have done what they did willfully. I mean, it really just means knowingly. You get double. You get an equal amount in what's called liquidated damages. So if the damages you're awarded by the jury is $50,000, the jury doesn't double it. They're not even told that. Post-trial, the judge doubles it.
Okay.
The other thing you get are all your court costs. Let me tell you, folks, if you go a year, 2 years in discovery, and then through a trial, even with a lawyer who you're on a contingency fee basis, and maybe that lawyer has been advancing all these costs for you, hoping that you're going to win and he'll get his costs back from a judgment, you may end up with $50,000 in costs by the end of a trial. Now, either that money is going to come out of your cut, or in an FMLA case, the judge enters an order saying, okay, you've shown me $50,000 in costs, Mr. Address. Looking at this and looking at that, I think there's $45,000 that I think are compensable under the U.S. Code based upon what is allowed. I'm ordering defendant corporation pay an additional $45,000. Well, so now you're getting your costs back, and so that money is now not coming out of your pocket. The other thing you get is attorney's fees. Yay! Why is that important? Let's take a rounder number. Let's say you got $100,000. Well, if an attorney is taking 33 1/3% on a contingency fee, he's taking $33,000 out of your pocket.
Right.
Let me tell you something. All you
Well,
folks,
without that attorney, though, you were getting nothing.
well, that's true. That's true. But and a lot of people think that, okay, contingency fees are 1/3. It's not. It's 1/3 for all the lawyers that you see on TV. Because what you really see on TV, personal injury, products liability, those are traditionally and always have been 1/3.
Okay.
When you get with lawyers like me, who are not doing that type, we're doing different types of statutory litigation, most lawyers charge 40%. So out of your $100,000, I'm going to grab 40%. Now, you may be happy with that $60,000, but I guarantee you'd be much happier if you got 100. In an FMLA statute, in a discrimination statute, in a civil rights statute, there are attorney's fees provisions. So that if you prevail, now again, post-trial, I'm filing a motion with the judge for attorney's fees. The other side is fighting me tooth and nail. You spent too much time on this telephone call. You spent way too much time taking this deposition. In the end, let's say my attorney's fees at what would normally be my normal hourly rate if I had taken the case on an hourly basis. Let's say the attorney's fees come to $75,000, and the judge awards me $50,000. Well, guess what? I've gotten more than I would have gotten on my contingency fee with you. And that $50 I get, I'm really happy. But you're happy too, because
it didn't come out of my
it didn't
my
come
part,
out
yes.
of your pocket. You got all of what the jury awarded
Right.
you. So that's what you get on an FMLA case. You get your losses. You may get some front pay. You get your costs paid. Maybe not all of them, but certain statutory costs.
And that's a case-by-case basis,
is,
depending
absolutely.
on how the earnings of that person.
Absolutely. And if you don't win big, if you win one claim out of 3, well, the attorney's fees are going to be cut accordingly. The costs are still the same, but if the attorney, we won the case, but he overreached, and a lot of this was a waste of time. The judge is going to punish me, and I'm still going to get whatever the court awards. That may be what I would have gotten from you. Maybe it's not. But that's the way the statute is.
Is this the type of thing that could settle before court?
All right. More than 95% of all civil cases never go to trial. If they did, cases would take more than 2 years to get to trial. Most cases settle. And in fact, it's been probably at least...
Well, that's what happens, I guess, when you get called for jury duty and you're sitting there and you're waiting and then y'all get to go home.
Either there's a settlement if you were called for a civil case, or if you were called for a criminal case, there may have been a plea.
Okay.
But most cases get settled way before the courthouse steps.
Okay. What is that, like a last-minute panic on the person's part?
Sometimes it gets settled very early. Sometimes it gets settled after the first key deposition is taken and one side or the other does horribly. If it's the other side that did horribly, I'm going to be seeking, I'm going to be going for the throat. And I'm going to exert more leverage to get the kind of settlement I want. And maybe now they're afraid to go to court. If my client is the one who just testified horribly, we have to, recalculate our expectations. And maybe we get a settlement, but it's not exactly what we had hoped. May still be better than we thought, but, everything depends. If we're taking a deposition of a key witness, and we think the witness is going to back our client's story, and our client is certain, they were there, they know what happened, and the witness is a current employee and is just afraid to tell the truth, and that nasty word, perjury, and they lie. Well, let me tell you something. That happens in every single case. People lie. My job when I'm taking a deposition is to have enough ammunition to pull the truth out of the lies. And almost nobody gets charged with perjury. So people will lie through their teeth. And that is why you have cross-examination. That's why hopefully you have a good attorney. But cases do settle early, they settle in the middle, and they settle at the end. But the other thing is that it's a creation that we've probably had now for about a decade. Every case has to go to mediation before trial. Judge won't allow you to go to trial without going to a mediation. And very quickly, a mediation isn't an arbitration. The person who is the mediator is not going to decide anything, not going to impose his or her will on you. A mediator is another attorney that both other attorneys have selected jointly, that is going to listen to both sides, initially in a conference room all together. Then you're going to go into different conference rooms. The mediator is going to engage in shuttle diplomacy and is going to try to persuade each side to move. The side offering money to offer more, the side demanding money to demand less, and he's going to use the weaknesses and the risks of your case against both sides. And very often, a really good mediator can settle most cases. And so then the case is over and it's not on the judge's docket anymore.
We've got about 30 seconds left in the show.
That's amazing.
We're going to have to carry this case over to next week.
Well, that's wonderful. Hey, look, next week I hope we have more callers. I'm glad for Bulldog and John who called in. Tell your friends. I'd like to chat with you all. I can hear your voice a lot more than talking. People say I talk a lot, and I filled up the show, but
we are done.
Okay.
All done for this week. You're listening to WPSL Port St. Lucie.